Hello, and welcome to Counseling, Progressive Discipline, and Corrective Action, part of the Performance Management training from Eye to Eye Workplace. Corrective action or progressive discipline is beneficial for many reasons. It helps to limit legal issues. It also communicates to employees that the employer has a fair and consistent process for addressing performance issues. Employees also benefit because they become aware of the organization's policy and have an opportunity to correct performance and behavioral problems. In this training, there are 3 sections: important elements of a progressive disciplinary process, verbal and written warnings, common problems with employee performance, and finally, terminations. Important elements, considerations for effective corrective action. Records and documentation. Employers must consistently and objectively record and document an employee's performance and any actions taken by the employer in response to an employee's unsatisfactory performance. Documentation serves many purposes. First, documentation provides clear communication between the employer and the employee about performance to resolve any issues and motivate the employee to improve their performance. Second, documentation ensures an accurate, complete, and preservable record. An employer should be able to produce written records that carefully, accurately, and completely document steps taken in the corrective action process. These records must objectively convey legitimate business considerations for the actions taken. The record should not reflect prejudice or bias against an employee or suggest that any aspect of the discipline taken against the employee was based on any personal traits. In order to ensure fairness and consistency in the administration of corrective action, all disciplinary action should be reviewed by your manager or an HR professional. An employer's discriminatory, arbitrary, or inconsistent treatment of similar situations is dangerous. To ensure consistency, clearly defined policies should be in place for the handling of documentation, including what will be kept in the employee's official personnel file. Retention policies should also be in place to ensure that these documents will not be inadvertently destroyed and that legally mandated documents will be retained for the required period. When there's an issue with performance, you need to have a rapid response. Here's an acronym that will help you remember the considerations for effective corrective action. Rules, application of policy, past history, investigation, and documentation. First of all, R stands for rules. Which rules were violated? Was the violated rule, procedure, or policy published? If not, can you prove that the employee otherwise knew about it? For employees represented by a union, were collective bargaining agreement procedures followed? Were Weingarten rights given if properly requested? Before disciplining an employee, you have to make sure that they understand what the rules were. A. Application of policy. Was the policy applied consistently? Were other employees treated the same way, and did they receive similar discipline? Or are there worse offenders? Are there extenuating or unusual reasons why disciplinary action is necessary? We're striving for fair and consistent application of the policies. P. Past history. How has this situation been handled in the past? Has the employee been warned previously for violations of other rules, policies, or procedures? Have other employees been disciplined for a similar offense? And is the degree of discipline to be imposed on this employee commensurate with the seriousness of the offense? Is it in line with the employee's past record and their length of service? I. Investigation. Was the matter investigated objectively? Does management have all the facts to make a decision regarding the employee's behavior or performance? And D. Documentation. What documentation do you have that supports your management decision? Does the evidence include names of witnesses, dates, times, and places, and other pertinent facts about all past violations, including the last one? And is there a paper trail? What does the last performance review say? Was there any written notice, performance improvement plan, or verbal warnings given? These are all questions you would want to consider before you take action. Let's talk about the right way to do verbal and written warnings. Remember that before you go to a verbal or written warning, you should be engaging in active coaching and counseling on an ongoing and informal basis. Remember the 5-step feedback process we talked about previously, that you want to give an objective statement, back it up with fact, tell them about the impact and the desired result you'd like, and end on a positive note. This is an important first step in ensuring that employees understand how to improve their performance. If coaching and counseling doesn't work, you move on to a verbal warning where you document the conversation. Advise the employee verbally of the violation or problem and the need to correct the issue. Even though this is a verbal warning, you want to write it down. When you give verbal warnings, talk to the employee privately in an office or a conference room or other quiet area with no interruptions. State the specific problem in terms of desired performance and actual performance, and refer back to previous casual conversations that you had about the problem, the coaching and counseling sessions. Give the employee a chance to respond and explain, and tell them the specific change you expect in their performance and what will occur if your expectation is not met. Have the employee confirm that they know exactly what you expect, but indicate your confidence in their ability to improve performance. Document this conversation and forward a copy to your manager or the human resources representative. If a verbal warning is ineffective at improving employee performance, you'll want to move up to a written warning. Advise the employee in writing of the violation or the problem. The written warning should include guidelines and timelines for acceptable performance, and should notify the employee that further discipline will result if the standards are not met within the prescribed time limits. Your HR function likely has a form to use for a written warning or performance improvement plan. Typically, you'd want to include facts about the infraction and the specific rule that was violated. You'll also want to refer to previous conversations and include a statement of the specific change you expect and what will happen if the expectation is not met. Allow the employee to respond and include any comments the employee made during this conversation. Also include a statement indicating your support for the employee to improve their performance, as you would by following the 5-step feedback process. The employee should be asked to sign a copy of the warning, and that copy should be placed in his or her personnel file. But if the employee refuses to sign, a note to that effect should be made on the copy prior to placing it in the personnel file. But check with your HR department to ensure that you're following procedures. Here are some tips for dealing with common employee performance problems. Many supervisors or managers have employees who are late or they miss work. The first question you'd want to ask is there a written policy on attendance and punctuality? And was the employee informed of the policy? Were there definite guidelines in terms of violations for attendance or tardiness rules? And what were the stated consequences of each violation? You'd also want to determine whether the employee was subjected to discipline for each violation in accordance with these guidelines. Was the appropriate discipline applied for every violation? And was the discipline applied uniformly and without discrimination? Finally, does the employee have an excuse, or are there any mitigating factors? And were these excuses investigated? Those are questions you're going to ask for each of these common problems, because we're striving for fairness and consistency, and we want to ensure that the employee was aware of the policy, but was unable or unwilling to abide by the policy. With regard to insubordination, there's probably no situation that's more frustrating for supervisors or managers. These are cases where employees challenge, criticize, obstruct, abuse, or undermine the supervisor or manager's authority. In these situations, you'll want to remain calm and rational throughout the incident. Before disciplining the employee, you'll want to ask yourself these questions. Were your instructions or orders clear? Did the employee understand that it was an order and not just a mere suggestion or request? And what was the justification for the poor behavior or performance? In terms of carelessness, you'll want to make sure that the employee was properly trained. And if you do take disciplinary action, that discipline was applied uniformly and consistently for every known violation of the safety rules. For low performance, you'll want to make sure that the employee understands the performance standards Review whether there were some extenuating circumstances that might attribute to the decline in performance. Also, investigate as to whether there is a decline in performance due to an extenuating circumstance such as family issues, health issues, or other specific issues that might be protected by law, and perhaps refer them to your Human Resources Department or your Employee Assistance Program if you have one. If you work in a union setting, be certain that you are respectful of union employee rights. They have a right to consult with a union representative when asked to participate in an investigatory interview that could result in disciplinary action. The employee or the union may invoke this right merely by requesting it. You do not, however, have to volunteer to the employee or the union that such a right exists. Also, employees may request that a union representative be present during the interview, but they can't request a particular representative. Their role is to support the employee, not to conduct the interview themselves or to bargain with you. Also be mindful of Weingarten rights, which may apply to non-union employees as protected concerted activity. Typically, unions stipulate 4 phases of the progressive disciplinary process: verbal, written, suspension, then dismissal. But depending on the union contract, some have coaching and counseling as the first step. So be sure what your collective bargaining agreement ensures if you're working in a union setting. As the final step in the disciplinary process, we have terminations. When planning a termination, make sure you ask yourself these questions. Is the reason for the termination job-related and non-discriminatory? Has the company complied with its own policies? Has an investigation been done? And would termination be consistent with past practice? Are there any other options to be considered? And has senior management or an attorney reviewed the termination? And when conducting the termination, get a witness to participate in the termination meeting. Keep the meeting short. Tell the employee the decision is final, but do not get into any debate. Communicate the reason for the discharge clearly, and provide the final paperwork as required in your state. Orchestrate whether the employee will be escorted out of the office or not, and also after the termination, limit information given to coworkers, and certainly limit information given in reference checks after the termination is complete. Let's summarize the information from this section. If you have issues with employee performance, counsel, coach, and talk to them on an informal basis before the situation gets out of hand. Remember the acronym RAPID and have a rapid response in terms of considering the rules, the application of policies consistently, past history, investigation, and documentation, which are all important aspects of effective corrective action. Other points to remember are coach and counsel early and often, and document all verbal warnings. Remember to allow employees to respond and ensure that you're applying the process fairly and consistently. Don't make the decision on your own. You have assistance with your manager or the HR department, and make sure that you're documenting the process at every step. And remember, corrective action or progressive discipline is beneficial for many reasons. It can help you avoid legal issues, and it can also help the employee to understand that they need to step up their performance. Thank you very much. This has been a presentation of Eye to Eye Workplace in the Management Series, Counseling, Progressive Discipline, and Corrective Action.